to all who have joined us by WebEx for standing by. Welcome to the open meeting of the Public Company Accounting Oversight Board. During the meeting, you'll be in listen-only mode. As a reminder, this meeting is being recorded and a recording is expected to be made available on the PCAOB's website. I would now like to turn to Chair Williams to formally convene the meeting.
Good afternoon and welcome, everyone. This is an open meeting of the Public Company Accounting Oversight Board on February 27th, 2024. We welcome those of you who have joined us today by webcast or dialing into the teleconference. Before we proceed with the agenda, I will note for the record that all board members are participating in this meeting and we are able to hear one another. The only order of business before the board today is a staff recommendation that the board propose for public comment a new rule along with amendments to an existing rule and form related to its registration program. To present the staff's recommendation, I will turn to our General Counsel, James Capoli. James, you may proceed.
Good afternoon, Chair Williams and board members. The Office of the General Counsel is pleased to recommend that the board issue for public comment a set of proposals related to the PCAOB's registration program. Proposed Rule 2400 would prohibit a registered public accounting firm and its associated persons from making false or misleading statements concerning the firm's PCAOB registration. Proposed Rule 2400 would emphasize the importance of honest communication in enabling investors and other market participants to make informed decisions about auditor selection, investment in securities, or other business decisions impacted by audits. Currently, there is no specific regulatory provision that addresses how registered firms or their associated persons should communicate the significance of PCAOB registration. And this gap is significant, considering that nearly half of PCAOB registered firms do not engage in any audit-related services for issuers or broker-dealers within the PCAOB's inspection or enforcement authority. Furthermore, even among those registered firms actively involved in areas within the PCAOB's inspection or enforcement authority, many provide a variety of services that extend beyond the regulatory reach of the PCAOB. Proposed Rule 2400 would be an important step towards curbing false or misleading statements concerning PCAOB registration, including the extent of oversight provided by the PCAOB. Additionally, we recommend that the board propose a new procedural mechanism to withdraw from registration firms that have ceased to exist or are otherwise defunct or no longer wish to remain registered. Proposed new paragraph H of existing PCAOB Rule 2107 would permit the board, under specified conditions, to treat a firm's failure to both pay annual fees and file annual reports for a minimum of 2 consecutive reporting years as a constructive request by the firm to withdraw from registration. Following notice and a 30-day opportunity to stop the withdrawal process, the board could deem the firm's registration withdrawn. In just a moment, I will be asking Vince Meehan to provide an overview of the proposals. Before doing so, though, I want to recognize several people who made significant contributions to this project. From the Office of the General Counsel, I want to recognize and thank not only Vince, but also Matt Golden and Drew Dropkin. From the Office of Economic and Risk Analysis, I want to thank Martin Schmaltz, John Cook, Hannah Lee, and Min Rand for their partnership and support. From the Division of Registration and Inspections, I want to thank Carol Swaniker, Michael Stevenson, and Abina Glasgow for their assistance. I also want to thank the staff from other offices and divisions, including Noah Berlin in the Division of Enforcement and Investigations, and Karen Wiedemann in the Office of the Chief Auditor, as well as Ted Serafini in the Office of International Affairs. Lastly, I want to thank the Securities and Exchange Commission staff, including the staff of the SEC's Office of the Chief Accountant, for their support and assistance throughout this project. Vince Meehan of the Office of the General Counsel will now provide an overview of the proposal, and then Martin Schmaltz and Hannah Lee of the Office of Economic and Risk Analysis will provide some additional remarks before Vince closes with our recommendation. Vince, I will now turn it over to you.
Thank you, James, and good afternoon, Chair Williams and board members. I'd like to begin by providing an overview of the recommended proposals which relate to the PCAOB's registration program. The U.S. public securities markets rely on public accounting firms that are registered with the PCAOB. As gatekeepers, these firms strengthen public confidence in the financial information that issuers and broker-dealers disclose to investors and other stakeholders. The PCAOB plays an important role in protecting investors and serving the public interest through its inspections and enforcement activities. Trust in the U.S. markets partly rests on the assurance that auditors are overseen by the PCAOB. Yet there can be a gap in the public's understanding of the PCAOB's regulatory reach under the Sarbanes-Oxley Act. This gap in understanding can lead to challenges in making informed decisions regarding auditor selection and investment strategies. Misconceptions that the PCAOB oversees all professional services provided by registered firms can weaken trust in the markets. Therefore, it's important that a registered firm and its associated persons avoid disseminating false or misleading information concerning the firm's PCAOB registration status, including the extent of the PCAOB's oversight of the firm and its services. Under the Sarbanes-Oxley Act, the PCAOB's inspections and enforcement authority extends only to work of registered firms that is performed in connection with audits of issuers and broker-dealers. Currently, about half of registered firms do not provide any professional services that are subject to PCAOB inspection or enforcement. Furthermore, even with respect to firms that perform some work within the scope of the PCAOB's inspection and enforcement authority, other professional services they provide, such as assurance engagements for clients that are not issuers or broker-dealers, fall outside of the PCAOB's regulatory oversight. Currently, the PCAOB does not have a specific rule or standard governing what firms or their associated persons can communicate to clients, potential clients, and the public concerning their PCAOB registration status. In our oversight activities, we have observed instances where some firms have inaccurately represented on their websites that PCAOB registration is a seal of approval or a mark of excellence. However, PCAOB registration does not constitute an endorsement or a symbol of audit quality. Additionally, we have observed firms leveraging their PCAOB registration status to promote work that falls outside the scope of PCAOB oversight, as well as referencing their PCAOB registration in auditors' reports for voluntary filers and other clients that are not issuers or broker-dealers. We are concerned that such statements may lead to investors and clients and potential clients and the general public to form inaccurate perceptions about the significance of PCAOB registration. This includes inaccurate conclusions concerning the scope of the PCAOB's oversight of the services provided by registered firms. We therefore recommend that the board propose new Rule 2400, which would prohibit false or misleading statements concerning a firm's PCAOB registration, including misrepresentations about the extent of the PCAOB's oversight of the firm's services. Proposed Rule 2400 would have three parts. First, it would generally prohibit a registered firm and its associated persons from making any false or misleading statement to a client, potential client, or the public concerning the firm's PCAOB registration status, including the extent of the PCAOB's oversight of the firm's services. Second, proposed Rule 2400 would provide a set of illustrative examples that would violate the general prohibition on false or misleading statements concerning PCAOB registration. These would include statements that claim the PCAOB endorses the firm or its services, are made by firms that are not currently providing any services subject to PCAOB oversight, refer to services outside the scope of the PCAOB's oversight, appear in auditors' reports for clients that are not issuers or broker-dealers, or are made by firms with pending withdrawal requests. Third, and finally, proposed Rule 2400 would codify the board's current practice of considering any false or misleading statement that an applicant firm may have made prior to applying for PCAOB registration. I would like to draw the board's attention to two aspects of today's recommendation. First, in circumstances where all of a firm's professional services in recent years have fallen outside the scope of the PCAOB's oversight authority, we believe promoting the firm's registration status without also explicitly stating that the firm is not currently rendering any services that are subject to PCAOB oversight is false or misleading. Such statements inaccurately suggest that the work of these firms is within the PCAOB's regulatory reach, potentially misleading potential clients, and the public about the true extent of the PCAOB's oversight of these inactive firms. Second, we believe it is false or misleading for a firm, when referring exclusively to services that are not subject to PCAOB oversight, to state or imply that the firm is registered with the PCAOB or subject to PCAOB oversight, without clarifying that those services are not in the PCAOB's regulatory purview. We believe that referring exclusively to services that are outside the PCAOB's oversight authority, a firm should either refrain from referring to its PCAOB registration to clients, potential clients, or the public, or if it opts to refer to its registration, it should prominently indicate that such services are not subject to PCAOB oversight. We also recommend that the board propose to update PCAOB Rule 2107, adding new paragraph H. This change would improve the PCAOB's registration program by clearing from registration firms that have ceased to exist, are no longer operational, or that no longer wish to remain registered with the PCAOB. Currently, a firm can be removed from registration only if it requests leave to withdraw from registration or if the PCAOB revokes the firm's registration as a disciplinary sanction. Proposed Rule 2107H would build on the current withdrawal framework and permit the board to consider a firm's lack of action, not paying annual fees or filing annual reports for at least 2 consecutive reporting periods, as a constructive request to withdraw from registration. Following written notice to the firm's primary contact, public website notice of the impending withdrawal, and a 30-day opportunity to stop the withdrawal process by emailing the registration staff, proposed Rule 2107H would permit the board to treat the firm's repeated failures to file annual reports and to pay annual fees as a constructive request for leave to withdraw from registration, and may deem the firm's registration withdrawn. The staff is interested in receiving feedback on all aspects of the proposals, and we recommend that the board allow 45 days for interested persons to submit comments, including in response to any specific questions that are set forth in the proposals. Additionally, the staff is recommending that compliance with proposed Rule 2400, if adopted by the board, would become effective 6 months after the date of commission approval of the new rule. Proposed Rule 2107H would take effect for annual reports and annual fees that are due in 2024, meaning that a registered firm that does not file an annual report or pay an annual fee in both 2024 and 2025 could be deemed withdrawn under proposed Rule 2107H beginning in the fall of 2025. Before I yield the floor to my colleagues in the Office of Economic and Risk Analysis to present their analysis of the proposals, I'd like to publicly recognize and thank several individuals for their contributions to this recommendation. First, I'd like to thank Chair Williams and her staff, as well as all board members and their staffs, for working closely with OGC to draft the proposal. I'd also like to thank my colleagues in OGC, specifically James Capoli, Matt Golden, Drew Dropkin, and Jennifer Williams, for their invaluable input and guidance throughout the process in developing this recommendation. I'd also like to thank my colleagues in the Office of Economic and Risk Analysis, specifically Martin Schmaltz, John Cook, Hannah Lee, and Min Rand, for their insights into the economics of the proposals. And finally, I'd like to thank the SEC staff, including the staff in the Office of the Chief Accountant, for their support and good comments on this project. And with that, I'll pass the mic to Martin for his team to say a few words about the recommendation. Martin.
Thank you, Vince. Good morning, Chair Williams and board members. The Office of Economic and Risk Analysis has performed an economic analysis of the proposed amendments As always, the economic analysis includes establishing a baseline of firm performance under today's rules, identifying a need for rulemaking, evaluating the economic impacts of the proposed amendments, and assessing reasonable alternatives. We believe the economic analysis contained in this release faithfully and even-handedly sets out the likely economic effects of the rule, and we look forward to receiving public input on the release. In particular, relevant data and analysis would be most informative to any future consideration of this proposal. I will now turn it over to our senior financial economist, Hannah Lee, to present the details of our analysis.
Thank you, Martin. Overall, proposed Rule 2400 is aimed at ensuring that stakeholders have access to clear and accurate information concerning firms' PCAOB registration status and the extent of PCAOB oversight, fostering a more transparent, fair, and efficient market. To gauge the extent to which firms may be making potentially misleading statements today, the staff reviewed the websites of about 10% of all PCAOB registered firms, totaling 167 firms. Our review found instances of registered firms making false or misleading statements about their PCAOB registration. For example, among the 167 firms reviewed, we identified 6 instances where firms implied PCAOB endorsement of the firm or its services. Moreover, 58 of the 167 firms we reviewed are not providing services subject to PCAOB oversight based on their Form 2 reporting. But 13 of these firms, about 22%, mentioned their PCAOB registration on their websites without making clear that they are not currently subject to PCAOB oversight. We understand that the interaction between SEC reporting requirements and the PCAOB's auditor reporting standards obligate registered firms to reference their PCAOB registration in auditors' reports for entities that are not issuers or broker-dealers. A staff review of 30 auditors' reports for voluntary filers confirmed that registered firms are mentioning their PCAOB registration in reports that are outside the scope of the PCAOB's oversight authority. We anticipate 4 primary benefits from the rule. First, proposed Rule 2400 would increase the accuracy of firms' marketing and other public statements, which could reduce information search costs for clients, potential clients, and the public, and aid them in making well-informed decisions regarding audit services. Second, the proposal would prevent firms from gaining an unfair advantage by inaccurately claiming PCAOB oversight, promoting fair competition in the relevant service markets. Third, increased transparency and reduced information asymmetry could enhance investor confidence, potentially increasing the supply of capital from market participants. Finally, firms that are currently providing services subject to PCAOB oversight may be motivated to offer more informative disclosures in their marketing, possibly allowing them to command higher fees for their transparency and the quality of services provided. The costs of proposed Rule 2400 would primarily involve reviewing marketing materials to ensure they accurately reflect the firm's PCAOB registration and the extent of PCAOB oversight, as well as establishing compliance processes to ensure future accuracy. Firms with existing pitch materials, engagement letters, websites, and other relevant communications to clients, potential clients, and the public that do not align with proposed Rule 2400 would need to update those marketing materials. Finally, firms would also incur the cost of evaluating their services to determine which of those services relate to audits of issuers and broker-dealers so that representations with respect to those services can be accurate. Those assessments should not impose significant additional costs on firms, as they would parallel analysis that firms are already required to perform when initiating engagements with audit clients and determining whether a potential audit client is an issuer or broker-dealer for purposes of existing PCAOB and SEC reporting requirements. Turning now to proposed Rule 2107H, we found that as of the end of 2023, 87 firms had not filed an annual report or paid annual fees for the 2022 and 2023 reporting periods. These firms would be eligible for withdrawal under proposed Rule 2107H. Firms that are no longer operational or are amenable to withdrawing from PCAOB registration would incur no costs when being removed from PCAOB registration. Firms wishing to stay registered with the PCAOB can stop the withdrawal process easily by sending an email to the PCAOB expressing their desire to remain registered. I thank our colleagues in the Office of the General Counsel at the PCAOB and the SEC staff for their support in developing the economic analysis. I will now turn it over to Vince to present the staff's recommendations.
Thank you, Hannah. In closing, the staff is recommending that the board issue for public comment a new rule along with amendments to an existing rule and form related to its registration program in substantially the form provided to you. Thank you.
Thank you, James, Vince, Martin, and Hannah. At this time, my fellow board members and I will have an opportunity to make a statement or ask questions of the staff. We will proceed in the order of seniority, and I will begin. Auditors play a vital role in promoting trust in our capital markets. Maintaining that trust requires transparency and accountability in how firms represent themselves and their work. Unfortunately, we have seen too many instances of firms promoting their PCAOB registration in a way that could mislead clients, investors, and others. Today, we are taking the first step to ensure there are consequences when firms or their associated persons misrepresent their registration status or what that status means with the new proposed PCAOB Rule 2400, false or misleading statements concerning PCAOB registration and oversight. Let's start by reviewing what PCAOB registration is and is not. Firms are required by the Sarbanes-Oxley Act to register with the PCAOB in order to perform audits of publicly traded companies and SEC-registered broker-dealers, or to play a substantial role in those audits. Registration and the accompanying annual reporting allow the PCAOB to keep track of the firms who are eligible to perform those audits and to understand which audits, if any, they are performing. PCAOB uses that information in planning its inspections and for other purposes. PCAOB registration is not a seal of approval or mark of excellence as some firms have advertised on their websites. The PCAOB does not sponsor, recommend, or endorse firms. And PCAOB registration is not a system for grading the quality of a firm's professional work. Additionally, just because a firm is registered with the PCAOB does not necessarily mean that all or any of that firm's work falls under the scope of PCAOB's Oversight Authority, nor does it guarantee its work is conducted in compliance with PCAOB rules and standards. The PCAOB's oversight authority extends only to a firm's practice in connection with audits of public companies or SEC-registered broker-dealers. Nearly half of the firms registered with the PCAOB are not engaging in any audit-related work subject to PCAOB oversight, and most others have some work that falls within the PCAOB scope and some that does not. Proof of reserve reports offer just one example of services PCAOB registered firms may provide that fall outside of the PCAOB's oversight authority. Last year, in response to well-publicized examples of some service providers, including PCAOB registered firms, issuing proof of reserve reports to crypto companies, the PCAOB's Office of the Investor Advocate issued an advisory. The advisory alerted investors to the fact that proof of reserve reports are not within the PCAOB's oversight authority, are not audits, and do not provide any meaningful assurance to investors or the public. The investor advocate warned investors to exercise extreme caution when relying on proof of reserves to conclude that there are sufficient assets to meet customer liabilities. Firms must also do their part as trusted gatekeepers to ensure that the information they share with the marketplace is not false or misleading. Under the proposed rule, a firm issuing a proof of reserve report and touting its PCAOB registration in that report would be considered misleading unless the firm also states that its work on the proof of reserve report does not fall within the PCAOB's jurisdiction. This is just one example. Proposed Rule 2400 would strengthen investor protections against false and misleading information by ensuring accountability in 3 ways. First, the rule would generally prohibit a registered firm and its associated persons from making false or misleading statements concerning the firm's PCAOB registration status, including the extent of the PCAOB's oversight of a firm's services. Second, the proposal outlines a non-exhaustive list of scenarios that would violate the general prohibition, including implying the PCAOB sponsors, recommends, or otherwise endorses the firm or its services, or connecting PCAOB registration to services not subject to PCAOB oversight. Finally, proposed Rule 2400 would codify the board's current practice of considering any prior false or misleading statements made by a firm or its personnel regarding the firm's PCAOB registration status, including the extent of PCAOB oversight of the firm, when reviewing a firm's registration application. The proposal also includes a new mechanism under existing PCAOB Rule 2107, withdrawal from registration, where if a firm fails to both file annual reports with the PCAOB and pay annual fees to the PCAOB for at least 2 consecutive reporting years, the board can consider the firm to have withdrawn from registration. PCAOB registration is not a marketing gimmick for firms. This rule would protect investors from misinformation by ensuring there are consequences when firms misrepresent their PCAOB registration status or what it means. I encourage all of our stakeholders to read the proposal and provide your perspectives. I would like to express my gratitude to those individuals who have significantly contributed to this proposal. Specifically, from the Office of General Counsel, I want to thank and recognize James Capoli, Vince Meehan, Matt Golden, and Drew Dropkin. From the Office of Economic and Risk Analysis, I want to recognize and thank Martin Schmalz, John Cook, Hannah Lee, and Min Rand. From the Division of Registration and Inspections, I want to recognize and thank Carol Swanaker, Michael Stevenson, and Abina Glasgow. I also want to recognize and thank Noah Berlin in the Division of Enforcement and Investigations, Karen Riedemann in the Office of the Chief Auditor, and Ted Serafini in the Office of International Affairs. I would also like to thank my fellow board members and their staff for their contributions to this proposal. I will now turn to my fellow board members for any statements they may wish to make. Board Member Ho, the floor is yours.
Thank you, Chair Williams. The proposal we're voting on today include two separate PCAOB rules. The first proposed rule would amend existing PCAOB Rule 2107, withdrawal from registration, by adding a new subsection H. I believe this proposed new subsection H is a good housekeeping matter by which the board could deem registered firms that have not fulfilled certain statutory obligations under the Sarbanes-Oxley Act of 2002 to have constructively withdrawn from registration. Under SOX, registered firms have both privileges and obligations. Perhaps the biggest privilege that registration with the PCAOB affords is the authority to lawfully issue or participate in the preparation or issuance of audit reports for any issuer, broker, or dealer. Conversely, two obligations that registered firms have under SOX are to submit an annual report and pay an annual fee to the PCAOB to cover the PCAOB's cost of processing and reviewing annual reports. Under this proposal, the board could elect to treat a registered firm's failure to both pay annual fees and file annual reports for at least 2 consecutive years as a constructive request by such firm for leave to withdraw from registration and to deem such firm's registration withdrawn. The proposal contains important procedural safeguards and quantifies the problem to be solved. For example, 87 registered firms, or approximately 6% of all PCAOB registered firms, fail to both file annual reports and pay annual fees for reporting years 2022 to 2023. The proposal states that its focus is on registered firms that have ceased to exist or are non-operational, and that one of its benefits is for PCAOB and the public to have a more accurate list of operating registered firms. I can support this rationale based on the good housekeeping principle, but I do wonder whether it will move the needle in terms of advancing our statutory mission to protect investors and further the public interest in the preparation of informative, accurate, and independent audit reports. The second proposed rule would establish a new rule, PCAOB Rule 2400, titled False or Misleading Statements Concerning PCAOB Registration and Oversight. Proposed Rule 2400 would prohibit false or misleading statements by registered firms and their associated persons. Specifically, a registered firm and its associated persons in statements to clients, potential clients, and the public must not mislead them about the significance of the firm's registration status, including the scope of PCAOB oversight over the firm and its services. The purpose of proposed Rule 2400 is described as preventing firms from making false or misleading statements to potential clients, and the public that could influence their decisions and ultimately confidence in the capital market. Staff has attempted to quantify the extent of the problem by conducting a review of 167 registered firm websites, representing approximately 10% of all registered firms. The results of staff's quantitative analysis reflected in the proposal suggests that approximately 17% of the 167 firms could be found to have violated PCAOB Rule 2400 if it was in effect today. Since the sample selection of 10% was a judgmental sample as opposed to a random sample, the extrapolated percentage of violations is likely to be lower than 17%, consistent with the proposal's statement that the sample may be biased towards selecting firms that could have false or misleading statements on their website. I wonder whether proposed Rule 2400 is a solution that warrants the staff time spent today and the staff time to be spent, especially when staff time could be better spent elsewhere to meaningfully advance our investor protection mandate. In addition, I am concerned that we are not mindful of the limited capacity of some of our stakeholders to respond to our ongoing stream of proposals with short comment periods. I am particularly concerned about smaller firms having the capacity to review the proposals and provide comments. A likely scenario is that they would not even comment because they're resource constrained. One purpose of the PCAOB's notice and comment rulemaking process is to adopt better regulations after considering stakeholder comments to help make sure that their perspectives on both the policy objectives and the granular details of our proposals are not overlooked. Without stakeholder input, we would be at risk of adopting regulations that may not fully consider all issues. While I will support these proposals, I look forward to reading the comment letters, especially on whether commenters believe that the proposal will move the needle in furthering our investor protection mandate. I want to thank the Office of General Counsel staff, particularly Vince Meehan, and Office of Economic and Risk Analysis staff, particularly Hannah Lee and Min Ren, for their hard work and their responsiveness to my questions. Thank you.
Thank you. Board Member Stein, the floor is yours.
Thank you, Chair Williams. The proposal before us today attempts to remedy two concerns. The first is actually what I call the good housekeeping seal of approval problem. The other is audit firms being allowed to remain on the board's registration rolls despite failing to pay the required fees or report the required information. The first issue, the good housekeeping seal of approval issue, occurs because almost any audit firm can register with the PCAOB. This is a prerequisite to being able to audit issuers listed on American stock exchanges, broker-dealers, registered investment companies, certain employee benefit plans, and certain business combinations. But it's a bit like a driver's license. Having a license is an important first step and necessary to get on the road, but it does not guarantee the quality of your driving or that you will even get behind the wheel. The PCAOB inspects registered firms involved in the performance of audits and activities related to the audits of issuers or broker-dealers. But many of the PCAOB's registered audit firms do not perform such audits or activities related to them. As staff mentioned, at present, almost 50% of audit firms registered with the board do not audit or play a substantial role in the audit of issuers or broker-dealers. Some registered audit firms could emphasize PCAOB registration when performing services or issuing audit reports, despite the fact that many of those services are not subject to PCAOB inspection. For example, a PCAOB registered audit firm might issue audit reports on a major cryptocurrency enterprise. If the cryptocurrency enterprise was not registered with the Securities and Exchange Commission or required by law or regulation to have an audit that followed PCAOB standards, the audit work of a PCAOB registered audit firm could not be inspected by the PCAOB. Imagine if colleges and universities simply allowed for registration, with some registered students attending classes and being graded, while other registered students did not attend classes and were not graded. The proposed rule would require registered audit firms to be upfront about the work they do and whether this work can be inspected by the PCAOB. The second issue involves firms that fail to file their annual reports and to pay their annual registration fees. The proposal would allow the board to treat repeated failures to pay annual fees and file annual reports for at least 2 consecutive years as a constructive request for withdrawal of registration if additional notice is given to the audit firm involved. So today's release provides practical solutions to some practical problems, and I support issuing it for public comment. I, like my fellow board members and division directors, would like to acknowledge the work of many of our staff in bringing this project to fruition. I've also have a long list of folks who've contributed, but I'm just going to say I thank the Office of General Counsel, the Office of Economic and Risk Analysis, the Division of Registration and Inspections, Noah Berlin from the Division of Enforcement Investigations, Karen Wiedemann in the Office of the Chief Auditor, and Ted Serafini in the Office of International Affairs. So I look forward to receiving feedback on all parts of today's proposal. Thank you very much.
Thank you. Board Member Thompson, the floor is yours.
Thank you, Chair Williams. I support issuing today's proposals. Proposed PCAOB Rule 2400 is meant to ensure that when the public is assessing audit firms, including when investors are relying on services performed by a firm, that the public and investors are not misled about the extent of PCAOB's oversight of the firm's professional services. Our hope is that the public will not base its expectations of a firm's expertise or quality solely on the fact that the firm is PCAOB registered. Indeed, through our oversight activities, we have observed that certain firms are emphasizing the fact that they are PCAOB registered to market themselves and thereby attract work. This type of marketing is problematic in cases where a firm's professional services are not subject to the board's inspection or enforcement authority. The mere fact that a firm is registered with the PCAOB does not mean that it is inspected by the PCAOB. In fact, approximately 50% of firms currently registered with the board do not perform work subject to the board's inspection authority. Through this rulemaking, we want to convey that PCAOB registration is not a seal of approval. We've heard that many times today. Without a doubt, the process for a firm to become registered with the PCAOB is well defined. The process requires an applicant firms to present to the board fairly detailed information, including identifying associated entities, describing quality control policies and procedures, and disclosing certain disciplinary proceedings. After reviewing a registration application and related materials, the board determines whether approval of an application is consistent with the board's responsibility under the Act to protect the interests of investors and to further the public interest in the preparation of informative, accurate, and independent audit reports. The board's approval of a firm's registration application does not, however, amount to an endorsement of the firm and does not speak to the quality or excellence of the firm's professional services. As such, it is important that a firm's messaging regarding its PCAOB registration status is precise and accurate, such that the public and investors are not unwittingly misled. With these considerations in mind, I fully support issuing the proposal to expressly prohibit false or misleading statements of material fact concerning a firm's PCAOB registration status. Relatedly, I also support expansion of Form 3 to require formally inactive registered firms to publicly report when they have completed work that is subject to PCAOB inspection oversight. And finally, I support the proposal to create a new mechanism for the board to initiate the withdrawal of firms that appear to be defunct or non-operational. Chasing such firms to comply with annual reporting and fee payment requirements is often futile, as such firms typically do not engage with our staff. If ultimately adopted, this new mechanism will enable us to have a more accurate list of operating firms. As with each of our rulemaking projects, it is important that we hear from our stakeholders. Given that, I encourage commenters to share with us their perspectives on today's proposal. In closing, I want to thank the PCAOB staff for their dedication and valuable contributions to this rulemaking process, including from the Office of General Counsel, James Capoli, Matt Golden, Drew Dropkin, and Vince Meehan. From the Office of Economic and Risk Analysis, Mark Schmaltz, John Cook, Hannah Lee, and Min Rand. From the Division of Registration and Inspections, Carol Swaniker, Michael Stevenson, and Abita Glasgow. From the Office of Chief Auditor, Karen Wiedemann, and from the Office of Internal Affairs, Ted Serafini. I also would like to thank my fellow board members and my staff for their engagement with me on this rulemaking process. And lastly, I would like to extend my gratitude to the Securities and Exchange Commission staff, including the staff of SEC's Office of Chief Accountant, for their support and assistance on this process and this project. Thank you.
Thank you. Board Member Bodick, the floor is yours.
Good afternoon, and thank you, Chair Williams. The PCAOB's registration provisions provide the gateway for accounting firms to perform audits of public company financial statements, sorry, my camera. Public company financial statements, and to serve their vitally important role to support our capital markets. This access has been correctly called a privilege for those firms that register with the PCAOB. As such, the registration rules have a unique and perhaps disproportionate role to play in allowing us to fulfill our statutory mission of investor protection and furthering the public interest in the preparation of informative, accurate, and independent audit reports. Firms that register with the PCAOB are authorized to issue audit reports for issuers and broker-dealers and to play a substantial role in an audit. That authority, in turn, means the firm is subject to PCAOB inspection and other oversight activities. A firm's choice to register with the PCAOB, to retain that registration, and to convey that status to the public comes with responsibilities. Today's proposal spells out some of those obligations. In particular, firms that hold themselves out as PCAOB registered must make sure they are doing so accurately and fairly. For example, a firm's registration does not mean that its entire professional practice is then subject to PCAOB oversight. Large swaths of that practice may remain outside our purview or may be subject to our oversight on occasion. And just because the PCAOB inspects a firm or an audit engagement does not mean that we endorse that firm or its work. How a firm represents its registration status to clients, prospective clients, audit committees, and other members of the public can lead to mistakes and confusion about the PCAOB's regulatory oversight. Today's proposal is about avoiding this misimpression. As I've read through the proposal, I ask myself two primary and main questions. First, how does the proposal align with the PCAOB's mission, vision, and values? Is its focus to protect investors, increase transparency, and/or raise audit quality? In other words, what is the why? And second, how would the proposal impact various stakeholders? What would be its effect on the public, on investors, on issuers, on audit committees, on firms, and on the PCAOB itself? This is the how. In the proposal before us, the why, as I see it, is that auditors have an important responsibility placed on them by investors and the capital markets, one that necessitates transparency to maintain trust. This proposal is about enhancing that transparency and protecting that trust by offering clients, prospective clients, audit committees, and the greater public clarity on what PCAOB registration means, and perhaps even more importantly, what it does not mean. The confidence of those who invest in our capital markets turn in part on the knowledge that the PCAOB is playing a role in overseeing the auditor's work. We want to clarify that role to ensure such confidence is not misplaced or undermined. As for the how, my focus is on what the impact of the proposal would be on those most involved in its implementation. I welcome hearing from all commenters, but want to emphasize a few groups in particular. First, the general public and investors among them. This proposal is focused on you and your understanding of and confidence in auditors' work, in our own work, and in the capital markets more broadly. Second, firms, and in particular smaller firms. This proposal may well change how you present yourselves and your work. We want to hear your thoughts on that potential impact. Third, public companies, broker-dealers, and other firm clients. Are there ways to make this proposal useful that we have not considered? Now, let me briefly highlight a few key features of the proposal. As the release indicates, proposed Rule 2400 consists of three main parts. First, there's a general prohibition on false or misleading statements about a firm's registration status when marketing or otherwise holding itself out to clients and the general public. This is a broad prohibition, but it is limited by subject matter, only with regard to registration and by communication type, marketing, and other similar statements. As a public-focused prohibition, this rule should not affect how firms do their work internally, just how they present that work and themselves to others. Second, the proposed rule offers special direction to firms about how to design marketing materials that accurately reflect the extent of PCAOB oversight and avoid the suggestion that the PCAOB is sponsoring or otherwise endorsing their work. The proposal makes clear that firms would have to assess for themselves whether they fall into a variety of categories before mentioning their PCAOB registration status. Third and finally, the proposed rule makes clear that false or misleading statements about a firm's registration may have consequences for future applications for registration. This was already the case, and I appreciate efforts to make our practices more transparent by codifying them. We are also considering a rule amendment for a new constructive withdrawal mechanism. Proposed Rule 2107H would allow the PCAOB to consider a firm that has failed both to file annual reports and pay its fee for multiple years as having effectively requested to withdraw from registration. The proposed rule offers some context. There are 87 firms that have neither filed annual reports nor paid fees for the past 2 years. 13 of these firms have not done so for over a decade. If this rule is adopted, that period of delinquency after adoption would be grounds for implementation of the withdrawal process. In conclusion, I am pleased to support this proposal. It endeavors to ensure transparency in registered firms' public communications and emphasizes our mission of investor protection and the public interest. I would like to end where the meeting began, focused on our dedicated staff. Their hard work and creative thinking in this project, and in particular, the discussions and other support they have provided me during my review is very much appreciated. Thank you to James Capoli, Matt Golden, Drew Dropkin, and Vince Meehan in the Office of the General Counsel, Martin Schmolz, John Cook, Hannah Lee, Min Rand in the Office of Economic and Risk Analysis, Carol Swaniker, Michael Stevenson, and Abina Glasgow in the Division of Registration and Inspections, Carol Wiedemann in the Office of the Chief Auditor, and Ted Serafini in the Office of International Affairs. Thank you very much.
Thank you. Unless there are further discussions from the board, I would now call for a vote on the staff recommendation. Board Member Ho.
I support the recommendation.
Thank you. Board Member Stein.
Aye.
Thank you. Board Member Thompson.
Aye.
Thank you. Board Member Bodick.
Aye.
Thank you. All votes are unanimous. The recommendation is approved. That concludes the PCAOB's open meeting for today. There is no further business. This meeting is now adjourned. Thank you for your participation. You may now disconnect from the webcast and teleconference.